Wow, I didn't realize the first question will relate to the rest of the questions. Okay, in the more commonly used standard contracts, there are of course contractual powers and mechanisms for you to handle such situations. So what if the client has signed a non-standard and very simplified contract prepared by the contractor? So how have you encountered such a situation where the contract is obviously when the contract is drafted by the contractor, it will lean towards their benefit lah, right? So
I've encountered it more as an advisory role when such situations happen now. And as you say, well, the contract is a contract. The client has signed it with the contractor, and most often than not, it will be at a disadvantage to the client. So we'll just say that, well, if it comes to a certain situation, you just have to find ways to terminate it, or you have to ride through the contract until the end because that's what they signed. In fact, this situation came about not locally, but overseas, whereby a young architect turned developer developed something overseas, and for them, they kind of signed the contracts with the contractor. And the contractor midway through the thing just says that, oh, I terminate my contract. And that's it. And the architect, so-called architect developer, has got no recourse, and being young and inexperienced, he came back to me as a friend and said, what can I do? And I said, well, show me your contract. And I read through everything and said, look, you have no recourse, just let him go and you're going to start all over again. I think that is the issues with currently, particularly houses. You get a lot of house owners getting offers from contractors, design and build arrangements, and often they're not familiar with the contract, and they just see the dollars and cents part of it and say, wow, I'm going to get my house at such a better rate than if I'm going to get an architect and everybody to start. And I think that's where they kind of fall into situations like that.
That's actually the topic of another expert
witness.
Another
subject.
No, but that's another topic of an expert witness that I recently concluded.
Okay.
Right? So in this particular case, there was a so-called contractor drafted, and then after that later, it was between main con and the subcontractor. Subcontractor failed to perform, and subcontractor said that, well, it was a friendly handshake, But then I said, so as an expert, my view would be basically very simple. I see your signature on 297 pages of the so-called handshake contract that you have signed. So whether you like it or not, in the eyes of the law, you have agreed to it. So you must perform to it, you see. So, as Stephen rightly fully put it, you better know what you are signing before you put your fingerprint on it. Yeah.
I think that applies not necessarily to the client and the contractor, so architects with client as well.
Yeah.
Yes.
There's a lot of fine prints that you need to read.
Okay, so with all on the topic of contracts, how do you feel about a scenario where the client or the contractor comes up with their own form of contract? You would then have to, so a few things I thought about was that you would then have to familiarize yourself with a new contract. Okay, then depending on how comprehensive the contract is, it may land you in dead-end scenarios where you have limited contractual power, because I think the contracts that we are familiar with, obviously, we have played out many scenarios. It's probably gone through many iterations already, and it drives you in circles, and much more time is needed to contract manage. So it leads me to the question do you think that architects should charge more for having to administer non-standard contracts?
Architects should charge more, period.
Correct. I agree. And for such situation likely, I'll not take on the project. It's too risky.
You don't even have a template for you to base on how to exercise.
Even if you charge more, you do need a lot of time to understand what's in the contract and to test out different iterations to see what are the possible scenarios that could happen. I think that will take a lot of time and effort. So even if, depending on really how much you charge, may not be worth the effort.
Actually, I wouldn't mind taking on if I had in that arrangement the powers to offer improvements to that contract. I mean, to me, very, very straightforward would be basically what are the client's obligation, what's the contractor's obligation, what are the client's remedies, and what are the contractor's remedies, and what is the arena for resolving disputes. These elements must be in the contract. And then beyond that, right, if you want to have your chicken rice, as I would put your chicken rice type contract, right, where you show a photo of a drumstick, but you deliver a chicken breast meat plate, right, that's separate. But I mean, partially because I'm so involved in the legal process of so many kind of things like that, I've come to realize why, rights, obligations, and remedies, these are my key go-tos for any contract form.
Yeah, which I mentioned, you require additional time.
Yes, correct.
I think that's...
And that's why you must charge more.
Agreeable, but how much more to make it worth a while? I mean, if you are really... Again, I think it depends on individual practices.
Yes.
All right. So if your practice involve you as an architect, not just as a contract administrator, focus, then you may not have the resources to spare the additional time and effort to look into those aspects of it. That is for my practice.
But actually, I'd like to ask that question back, you see. When we pitch our fees, for example, are we pitching it to so-called the blue book with that little graph down there? Or do we actually look into the resource and manpower requirements to service the account? When in my days as a self-practicing sole proprietor, I used to follow the blue book, so to speak, and I realized that it was actually not equitable to the effort put in. Right now where I am, we are totally the opposite, The minute, even if you want me to do a small little guardhouse or what, right, I will pitch in, who needs to be there, how many hours, and all this kind of thing, even as an estimate, right, and arrive at a fee proposal. So I think really, back to the earlier mention about how do we charge and how much is it, right? It's about a matter of manpower, as you said, versus resourcing and whether or not it is worth the financial reward. That's basically it.
Yeah.
So, I mean, one very veteran architect used to tell me when I was much younger, was saying that, you can't keep running away from unsavory work, because if you do that, right, you have nothing to practice with,
How about you? Have you encountered scenarios where you might have to?
Not really. So far, we have been practicing based on either SIA or PSS COC. So, provided we can influence the contract. If you have already signed a contract with a contractor, for example, the client already signed a contract with a contractor, and ask the architect to administer the contract, I don't think it's wise and also not fair to the architect who was going to administer the contract also. So unless, like what Harold has said, you are able to influence it and include the terms that is help us to administer the contract. If not, I don't think it's wise for us to administer a contract that is not drafted by us.
Or rather, it takes our teeth away. You see.
Yeah.
Because for me, I work on the landed houses.
Yes.
So obviously the clients engage me already, and then I have my service agreement with the client. And very often when we call for tender, they might have uncle's friend's friend or whatsoever, and they pull all sorts of contractors in, and there's a lot of influence, different type of influence going into their head, So I quite often encounter scenarios where they say, of course I would advise, maybe go for SIA contract, but they say, no, they tell me that this contract is very good and everything. So I always have to look at different kind of contracts, and of course, in my opinion, I'd rather just run the standard one because it protects the client also. But quite often they don't align, they may not align with that, and they end up signing a simple contract.
But do you adapt some of the SIA portion to that self-constructed contract?
I do spend a bit of time to advise on certain clauses that should be put in, but of course, like what you mentioned earlier, we have to put in additional time. But I don't have an opportunity to, or rather, I haven't tried claiming for additional fees in that aspect, but maybe I should start. but yeah, so there are situations like that. But you run in a situation where you are engaged, your service agreement, you know, you're supposed to manage the project and administer the contract, but the contract is garbage. So you don't have a lot to work on. And there was one where the contract was so simple, and when the works were not satisfactory or they were behind schedule, I just had no contractual power except but to write a letter or email of plea to the contractor to say, please hurry up, the clients have been, you know, renting a place for too long. So those are the situations. I think it's more evident in landed houses, contracts for landed houses. Yeah.
I think you brought up something which I think we were just discussing earlier, in the sense that what is in our appointment agreement. I think through the years as we practice, we tend to tweak our appointment to kind of cover those loopholes.
Yep.
And I think this is one possible area to say that, well, you know, your role in your agreement is to administer this form of contract. You know, anything more is either chargeable or you know, not acceptable. I think, well, through 30 years of setting up my practice, you know, along the way we keep changing our letter of appointment to plug in all, you know, we got caught by the client in finding a loophole in there, and you keep plugging in all this.
It
loopholes
just
along
gets
the way.
more and more.
Yeah.
Thank you for that. Tonight I'll put that in. Okay, so another question is, should we even be involved when there is a dispute between the contractor and client?
I think you have no choice.